Hi there, I'm attorney Kelly Longtin and founder of Kelly Longtin Law, and I want to thank you all for watching this video. Today I want to talk to you about why an estate plan should not be a set it and forget it endeavor. And as we all know, life just happens, and there's really nothing that any of us can do about it. However, some of the most common life events can have a dramatic effect on your estate plan. And if you think your estate plan is like a slow cooker and you can set it and forget it, you and your loved ones may be in for a huge surprise when it's time to put your plan into action. So let's take a look at some common life changes and the impact they may have on your already established plan. So let's begin by talking about the birth of a child. Now, it's common for parents to have their estate plan prepared after the birth of one of their first kids or child. However, depending on what provisions are in the first iteration, a second child might have difficulty getting their share without court involvement if the clients do not revise their plan after the birth of a subsequent child. And there's always, for the older folks that may be watching, there's always a birth of a grandchild. Now, many grandparents love spending time with and supporting their grandchildren in any way that they can. However, depending on the family structure, a grandchild who has been left out of an estate plan may have no recourse and may miss out on the opportunities the grandparents may otherwise have intended their grandchildren to have. Now, a death of a family member can clearly affect your plan. Now, a number of people are involved in creating a will or a trust. There are those who are creating the estate planning documents, so either the will maker or the trust maker, and those who receive a benefit from the estate planning documents, and those are called beneficiaries. And those who are in charge of carrying out the documents' instructions, so the personal representative or executor or successor trustee. And aside from the will or the trust maker, the death of any of these individuals can greatly impact the estate plan. A beneficiary's death may mean that others receive a larger share, or that deceased beneficiary's descendants receive that share. So reviewing your estate plan to make sure that your wishes will be carried out is important, even if your first named beneficiary is no longer living. We all know how exciting purchasing your new home or your first home can be. Well, purchasing a new home can dramatically impact trust-based estate plans. Typically, for this type of plan to work as intended, either all of the accounts in the property need to be owned by the trust, or the trust needs to be named as the beneficiary. Usually, when you create the trust, you prepare a deed, transferring your home to it, making it easy to ensure that the trust owns your home if your estate planning attorney recommends that strategy. However, if you decide years later to buy a new or a second home, you need to remember to fund your new real estate into your trust to avoid probate. Now, when you purchase real estate, most title companies will assume that you are doing so as an individual, or if you're married, as a married couple. If you want the home to be purchased in the trust name, you'll need to notify the title company or follow up with your estate planning attorney after the transaction has closed to transfer the new property into the trust. And if you do not transfer the property to your trust, then upon your death, it will go either to the surviving owner if it's owned as joint tenancy with rights of survivorship or tenancies by the entirety, or through probate if you owned it individually or as tenants in common. And marriage can definitely affect your estate planning. And marriage is an exciting and sometimes a complicated process. You may have your own money and property, and over the coming years, you will probably accumulate money and property jointly with your spouse. Keeping straight which property is separate and which is joint, outlining your wishes for what you want to leave to your spouse, and deciding what decision-making authority you want your spouse to have in the event that you're unable to make your own decisions are all crucial elements that an estate plan should cover. If you do not update your estate plan after your marriage, a court may have to be involved for your spouse to be able to make decisions for you and receive what you want them to have. And as you can imagine, a divorce will certainly affect your estate plan. And it's natural for married couples to name each other as their trusted decision makers in their estate plans. So, for example, as executor or personal representative or trustee or agent under financial and medical powers of attorney. It's also probable that you named your spouse as a beneficiary of some of your money and your property. However, if you and your spouse divorce, chances are your wishes will then change. Now, state law varies as to the effect of a divorce on a person's estate planning. To avoid complicating matters, it is best for you to update your documents so there's no question as to what your intent was. Because of the varying treatment under the law, it's important that you meet with an estate planning attorney after your divorce has been finalized to replace your trusted decision makers and name new beneficiaries. The last thing that you want is to give your ex-spouse a reason to be involved in your estate plan, even if they'll receive nothing. Now, I hope that some of you have taken the crucial step, or at least you're here watching this video, so you have an intention of taking the steps to preparing an estate plan, rather than relying on your state's default rules. So I applaud you for that. However, estate planning is not just a once-in-a-lifetime event. Your plan is a set of living, breathing documents that can be impacted by many common life events. And if you or your loved ones have experienced any of the events that I've just mentioned, a child, a birth of a grandchild, death of a loved one, a marriage or a divorce, any of those things have happened since you last updated your estate plan, then you definitely want to reach out to your estate planning document and or estate planning attorney and have your documents reviewed. So you don't want to wait until it's too late for that to happen, because that can lead to a disastrous result. So I hope you all found this beneficial, just talking about the need to update your estate plan based on life events that may happen to you. So I want to thank you for watching. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families.